Yeah, clause says that you'll pass due debts, including but not limited to utilities, NSF, NSFE, late charges, from rents. I don't know if that's been tested. We all like to use that. It's a good thing to have in there. That's to try to keep attorneys from doing some forensics analysis of your ledger and say that you had to go back 6 months, back out a $25 NSF fee, and do that on a 10-day notice, and because it was included in your 3-day or 3 days defective. That's the kind of nonsense you get into, but this type of clause may help prevent that. Maintain a good ledger. I've had people come in and bring me napkins, crap scribbled on it, say, I want to pick my tenant. I've had people, I say, how much does they owe? I don't know. Well, you know, what can I do? I see, you can only do so much with the facts you bring me. Treat it like a business. A lot of these people that do this get into it accidentally, and they don't treat it like a business. You need to treat it like a business. You need to keep accurate rent rolls, okay? Keep a ledger. It will bite you if you don't. Tenancy maintenance, document, document, document. We talked about that. A lot of that means memorialize things afterwards. We talked about the text message back here. It might be a verbal conversation. It might be a phone call. Follow up and memorialize that in writing. Write a letter per our conversation, per our phone conversation on each date and time. You know, this is the deal. And if you disagree with that, get back to me within 5 days or 10 days or something. If they didn't, you know, you win that argument. And those are admissible. Those are contemporaneous notes. They're also business notes, which is 2 exceptions they get in under the evidence rules. Okay? If you keep those kind of notes regularly, you can get those in as evidence. It's not hearsay. Obviously, digital photos, cheap insurance, keep accurate rent rolls and ledger. We talked about that. Keep a maintenance log. It's not just enough to go out and fix it when they say it. Document when they called you, or have a system that they have to put some sort of request in, documentation, and when you started it. Tenants always think that 5918, what is it, 060 says that you've got to start this or finish this within those 24, 48, 72, and 10 days. That's not true. You have to start it. You have to start it within those time periods. You don't have to finish it within those time periods. So that might mean going out and taking a look at it and say, you know, it's Christmas Eve, your fridge is dead, I'm not going to be able to fix it, I'm not going to be able to get it until the 26th, right? So keep records of that stuff. Again, if you keep records and then you're at a hearing and they say, well, they didn't come fix the mold, and you flipping through your records and there's no request of any mold issues or whatever, the lack of evidence is also evidence in that, and it is admissible as long as you keep good business records. If you don't keep those records regularly, then it's not admissible, okay? So the lack of it can be admissible if you're doing it right. I'm sorry I'm trying to fly through this, but I don't want to miss this stuff. Memorialize all conversations. We talked about that. Keep a notebook. At the very least, even if you don't send them a letter, write it down in your notebook. Keep a logbook that memorializes all your conversations. Be proactive in sending periodic letters, maintenance and habitability requests, maybe every quarter. Send a letter saying, do you have any maintenance issues or habitability issues? Please let me know within 10 days. If you're doing that regularly, then when you show up to the hearing and they're going to try to say, well, they didn't fix this, so I should have a diminution in rent. I shouldn't have to pay this much. And the court can't decide at a show cause hearing how much that diminution should be. They have to set up a trial. You can pull the rug out from underneath them and say, not only did my contract say you had to promptly request or report and request, but we also sent out quarterly letters asking and you didn't answer. So there isn't anybody that can argue you reasonably should have known about the problem, right? It's good insurance. Expect any email or letter or text that you ever send to show up in court, okay? So you might not want to threaten to throw them out